Missouri. I have my old friend, Eric Abramson, with me. Eric, how are you?
Great. Thanks for having me.
Absolutely. So, Eric, I was excited to have Eric on the show, on our Facebook Live show. We do this every week at 3:00. We call it Ask a Lawyer because we try to ask a lawyer. The reason why I wanted Eric on is because I get a lot of criminal questions on this show, and I just don't know the answer to them. And Eric, although he does personal injury too, he's an expert in the criminal area and does really well in that. So welcome today to our Facebook Live show, Eric.
Awesome. Thanks for having me again. I always knew I'd be famous, Gary. I just didn't know it'd be done this way,
I don't know, for like the one person watching, right? So at least we're not just talking to each other. Eric, how do I know you? How do we know each other?
I've known you since I was a kid. You were through family friends. I did an internship with you when I was in law school. It's been a long time. You still look pretty young too. You got that going for you. So
I don't grow my hair long anymore to hide the gray, so I shave it. You have the short hair too.
I thought you had the beard going though. You got rid of that?
I do. I don't have, because it's all gray now, so I don't grow it out anymore. You have the strong facial hair gene.
Yeah, like 5% gray coming in. It's coming in.
My wife tells me I look old whenever I grow it. I think it's so that I won't grow it. I think she just says that. But, I was thinking of growing it out again for the winter, starting now, to get it all nice and going. So Eric, tell me. So I looked on your website, defenselawyersstlouis.com. You have great reviews there. I know you represent a ton of people. Your business is booming, it's growing. Tell us about the kind of practice you have, and then we're going to jump into some questions.
So I primarily handle criminal defense matters and traffic matters in Missouri and Illinois. I also handle personal injury, but I was able to build a practice from the ground up, starting with criminal defense. And I would say that that's my bread and butter. I have the most experience with that. It ranges from stealing to violent crimes to DUI, and I've just kind of been able to build up a following that way. And, you really do a lot for people when they're up against the wall and facing jail or prison time. And, I figure if a client can trust me with that, they'll trust me with a car. They can trust me with anything. And I think that that's really helped. So.
That's great. So I'm going to start off with some questions. So next week, my second kid takes their driving test, turns 16, is going to be on the road. And my mom, who is a former kind of family law, did a little criminal, and then was a judge. She told me when I was a kid, if the cop pulls you over, don't let him search your car. And she did that with my brother too. And we listened to her. Now, sometimes the cops were mad at us about it, but it worked. And then I was telling this to my daughter, and I was like, so if they ask you, like, why can't you search my car? Say, because you don't have probable cause. So, but let me ask the criminal lawyer, if you're pulled over for a routine traffic stop and the cop asks to search your car, what do you do?
I always tell my clients to blame me. So they can say, like, for instance, I had a client call me. Now, I don't know why I answered. It was about 2 a.m, but he said, he told these cops, listen, I tell them you got to be respectful, but, I respect what you're doing and your job, but my lawyer would be very upset with me if I don't exercise my right to refuse to consent to this search. And, put it on me. I understand that in that situation, there's a lot of pressure in, like, all law aside. I mean, I can understand why you think it makes you look guilty. But, the truth is, if there's nothing in your car, you shouldn't make a habit out of letting them search your car for no reason. They'll be going through your belongings. You'll be on the side of the road for forever. If they ask you to search their car, usually they don't have probable cause. Sometimes it might be iffy, but a simple consent search might just make it easy for them. But yeah, it's just never a good idea to be in the habit of doing that.
What if they threaten and say, listen, if you don't let me search now, I'm going to go get a warrant. We're going to impound your car. We're going to blah, blah, blah.
That's typically the kind of tactics they might use in that scenario. However, I mean, for instance, let's say they pulled you over and there's marijuana smoke coming out the windows. They have their probable cause. If they don't have probable cause, they might have to threaten you like that and feel like they've got to do something along those lines to get to do what they want to do. But there's a reason why they're not already searching your car, and that's because they don't have it.
And you may have friends in your car or something, although you may not have any weed on you or whatever. One of your friends might or something.
Right, and you know what, you can bet if you might think they're a good friend, but if they have a stolen firearm or something in the car, and all of a sudden it's found and they're not owning up to it, that can really put you in harm's way. I'd like to think
shoving it under the seat or something.
Right. My clients, my younger clients, they constantly have other people in their car, and that's usually, they think they know them well, but all of a sudden, there's some drugs or there's a pistol in there, and all of a sudden my client says, oh yeah, my friend, all of a sudden he's acting like he's throwing me under the bus. That's what people do when they have that stuff on the line. They have quite a bit to lose. So,
all right, we're starting to get some questions. I'm going to go to them in a minute, but I got another question for you. So, what if a cop asks you to blow, or what if they ask you to, meaning breathalyzer, or what if they think that you're imbibed or drinking or on drugs or something and ask for a blood test? What do you do then? I mean, you probably get, is this the question you get the most?
Yeah, so it's not 100% that simple. If you have never been charged with a DUI before, especially in Missouri, if you feel like there's any chance of you producing a breath test where you blow over 0.08, if you feel like it's at all out there and at risk, you should absolutely refuse. The difference is if you do refuse and you end up taking probation in the criminal case, we can get something called a confession usually. So you will not ever lose your license.
What's that called?
It's called a confession. So there's two sides to the DUI. In Missouri, there's the criminal side, which is whether or not there's jail, probation. And then there's also the civil side with your driver's license. If you don't blow in the breath test and it's your first offense and you're respectful to the officer, you can end up not losing your license at all, not having to change your insurance. On the other hand, for instance, if you have a prior DWI, let's say you've already had a DWI, it resulted in probation, you got the confession. If you're pulled over another time, the only way, if they think you're drunk, the only way you're going home without a DUI charge is to blow under 0.08. And they're going to charge you if you don't blow, and they're going to charge you if you blow over. So I always say in that situation, stall it out if you think you can get yourself below that 0.08. Actually exercise your right to a lawyer. Actually call one. Tell them you don't want to produce a breath test there. You want to go to the station. Time is everything. You can generally digest one cocktail or one beer per hour. Buy yourself as much time as you can, and you have to make that decision. If you want to pay a lawyer $20,000 to try your case and there's no negotiating, then yeah, don't blow. But you're not going to go home without a DUI charge unless you blow under in that situation. So
if you go and try it and beat the rap, does that help you on the civil side? There's different standards. I've had clients where they got, for instance, there's this one gentleman who was intoxicated driving on the highway, and he was very intoxicated, and he's like, hey, I don't know what I'm doing here. I got to pull over. This is dangerous. He pulls over. The police came up. He had his key in the ignition, and they charged him with a DUI. They chose to drop the criminal charges. The prosecutor saw that he was correcting his behavior. They dropped the criminal charges. That did not help him on the license side. They don't need to prove that you were driving intoxicated beyond a reasonable doubt to suspend your license. It's a much less of a standard, and it can help either way, but usually those are just seen as distinct matters. All right, so let me see if I got it right. If you've never had a DUI, you should refuse to blow. If you've had one before, you should say, I want to do it at the station, or ask for it. What about asking for a blood test or delay it as much as possible?
You want, all right, if you think it's close, let's say you had 2 beers and you were out for like 2 hours and you don't know. You're never really going to know. But if I've had a prior DWI and I think it's close, I am buying time before I produce a breath test. And that's just my opinion on it. A lot of lawyers will tell you different things. But what I'm trying to do in that situation is go.
Well, you're in the trenches. You know this stuff. Go ahead. Sorry.
Yeah. You buy time. You call a lawyer. You tell them you don't want to do the breath test there. There's a 15-minute period where they need to observe you before you blow in the breath test, to make sure that you haven't vomited, you got nothing in your mouth. Stuff like that can impact the result. So you have those 15 minutes. What you want to do is talk to a lawyer, exercise as much of your right as you can to talk to a lawyer, delay it, buy yourself time. Hopefully by the time you actually blow into the breath test, you are under that 0.08 and you get to go home and without a criminal charge.
Eric, does that change if I know you do work in Illinois too, you're an Illinois lawyer and do criminal work over there. Does that change if you're over in Illinois, the scenario you just painted for us?
Yeah, the scenario is way different. For a refusal to blow in like St. Clair County or Madison County over in Edwardsville, they basically don't set aside your license suspension unless they see a reason to based on the evidence. So let's say you're real drunk and you got pulled over and it's a first DUI, you refuse to blow, but you're stumbling and you're falling on your face, you're not going to be able to get out of that situation without a license suspension. But if you handle yourself well and you're respectful and you don't, do the field sobriety and the walk and turn and all you have is a cop saying you smell like alcohol, you might be able to avoid your license getting suspended.
So tougher calls in Illinois, depending on the jurisdiction and everything.
Definitely, it's definitely tougher, but Illinois does it way differently. Everything is dealt with in the criminal court. So you're dealing with
is there a separate license suspension system, or is that in the criminal side?
It's separate, but it's handled in the same courtroom by the same prosecuting attorney, and so it's a little more straightforward in that sense. That being said, I'm not exactly batting 1,000 in those. It's about each case. A lot of people know you can refuse the breath test, but not a lot of people know that you can politely refuse any field sobriety. So if they ask you to do the walk and turn, a lot of people don't understand that you can refuse to do that, and there's a polite, appropriate, professional way of doing that. And I think that helps.
So should you do the field sobriety test short of the breathing?
I always say no, because there's only one person watching you do the field sobriety typically, and it's the person who pulled you over, and it's the person who thinks that you're intoxicated. And it's like a student grading their own paper. If you walk that walk and turn perfect, heel to toe perfect, this person is less inclined to write, a paragraph about how sober you seem when they're trying to charge you with the DWI. I always tell my clients, by doing field sobriety, you're agreeing to allow them to write down clues of you being drunk, and regardless of how you perform.
And it doesn't matter how you do it. It matters what the officer writes.
It does. And, it's you're putting yourself you're not putting yourself in a great position by you can do the alphabet perfectly, but at the end of the day, it's going to be that officer's word against yours on how you did it. And,
how have you heard a million stories of clients saying, I did the field sobriety perfect and they wrote it up wrong, blah, blah, blah.
The story I hear most common, they wanted me to do it on an incline. It was cold outside. And you know what, honestly, I get that. I would be extremely nervous. So I might be shaking, because if you don't understand, as lawyers, I understand that, you're kind of screwed already when you agree to do the field sobriety. Most people think if they do a perfect walk and turn, they're going home. So there's a lot on the line. I can imagine that they're shaking and not really able to perform as well as they'd like.
Can I do a shout out to your dad, Ernie, real quick?
Yeah.
Greatest dentist. Are you still have offices near him?
Yeah, I meet at the office above his by appointment.
Yeah.
So yeah, but mostly people are there to spend money on his dental work, unfortunately. But I go there by appointment. So
I share offices with one of my old friends from junior high. So that's all right. You know what? Why hang out with people you don't like, right? Hang out with people you like. So no, I love your dad and your mom. Here, all right. So we're getting a lot of questions. I'm going to start rattling some off to you. I'm just picking them. I'm going to try to get to them all. Now we are talking about Illinois. What's the difference between now Illinois marijuana is legal? So how does that affect? I got two questions. One is we've been talking about drinking and driving. What about smoking the weed and driving? And number two is, does that matter on the legality of it from state to state?
it's extremely. I've handled cases where people are charged with a DUI. A lot of people ask, what's the difference between DUI, DWI? It's not really as clear cut that one means something over the other. But if you're driving under the influence of marijuana, it is very difficult to prove that. It's a DUI/drug intoxication. It could be pills, it could be marijuana. The reality of it is, through a urine sample, they can prove that you have ingested or smoked marijuana within the last 30 days. Some of my clients have provided some overwhelming evidence of them driving under the influence of marijuana, like telling them that they are, thinking it's not a big deal. But the truth is, I mean, people who are getting charged with that, it's usually because you gave it to them. And I've had one client that had never used marijuana, and he was so out of it, I'll just say, that there was no way he was getting out of that without a charge, crashing the car, you know. But yeah, it is a lot more difficult to prove that. I always tell my clients, you know, I'm not here to parent you, but if you're associating your marijuana use with vehicles, that's usually a very bad idea. A lot of that, Gary, depends on which jurisdiction you're in. In Missouri here, if you're holding less than 35 grams and you're not using it while you're driving or in the car, everything should be okay for you. I mean, the worst case scenario is you get a misdemeanor ordinance violation for having a possession. If you volunteer that you're smoking as you're driving, that's not good.
So it's harder to catch you, and you don't find officers making people do urine tests. It's harder to catch you under the influence of marijuana.
It's harder to prove that in that moment you were driving under the influence of that and you didn't have full possession of your faculties while you're driving. It's very hard to prove that. I see these cases when they pretty much give the officer all the evidence required of them. Or what? They smell like weed, or there's smoke coming out of the car. What do you mean? They roll down the window, smoke's coming out. They might have they have it in their hand. They have it right there, and they'll admit. A lot of people don't know that you can be charged for driving under the influence. They think it just applies to alcohol. I've had a lot of clients get charges for driving while under the influence of pills, even if they have a prescription. You got to be in possession of your faculties.
All right, these are the two questions. Let me finish with the marijuana, and then we'll go to prescriptions. Davey asks, now that Missouri has cannabis legal for medicinal use, we know Illinois is legal for everything. Is the excuse of I smell weed in the car a legitimate excuse for an officer to search your car at a traffic stop?
So the law is kind of on their side there. It does provide probable cause. Some of my clients have told me before that they're claiming that they lied. It didn't smell like marijuana when they pulled me over, and that is difficult to prove that it didn't. But that does operate to their officer's advantage if they pull you over and it smells like that.
Is there a different penalties for driving under the influence of drugs versus under the influence of alcohol? Is one worse than the other?
So
otherwise,
yes and no. A lot of my clients who get charged with driving under the influence of drug intoxication, the criminal side is treated very similarly. You know, if you don't get in an awful car accident, harm anybody, and this is your first time, you can usually keep a conviction off your record without an issue. But when you're driving under the influence of alcohol, they're more likely going to issue a license suspension that you'll have to defend. My clients that have been charged with marijuana-related DUI or pill-related DUI, those individuals, they have to deal with the criminal side. Oftentimes, we can manage a good result, but they don't usually suffer a suspension of their license or have to even defend themselves to the Department of Revenue. So usually the alcohol is what can get you double tapped with the license suspension and the criminal case.
As part of this, when you work out a deal or you work out a plea deal, is that what you mean in terms of trying to avoid a conviction? You do some type of a plea where they have some consequence, but not a conviction for that offense consequence?
That's correct. I mean, my clients always ask me, am I a felon or do I have a felony? You know, in Missouri and Illinois, it's not that simple. In Missouri, there's SIS and there's SES.
What's the difference?
SIS is just simply a non-conviction. So if I got an SIS...
Suspended imposition of sentence versus a suspended execution of sentence.
Correct.
So an SIS is a non-conviction. I interrupted you. Please continue.
You're all right. SIS would be a non-conviction. So if I get probation and I'm successful, I get off probation. I've not been convicted. Did I plead guilty? Yes, but I'm not convicted. So if you got an SIS on a felony and you walk down the probation, you have not lost your gun holding rights. You have not lost your voting rights. In SES, it comes with what they call a backup. You plead guilty, you're convicted, and you're actually sentenced to jail or prison time. And that's on the line during your probation. So if you screw up probation bad, they can execute the sentence. And Illinois has very similar laws. So usually for a first-time DWI, if you didn't commit an assault or hurt anybody or do anything outrageous, you can typically avoid a conviction. So. But if you are convicted, is this a felony? Is a DUI a felony? So typically speaking, and there are different circumstances, a first DWI is typically charged as a Class B misdemeanor. A second DWI will be charged a Class A misdemeanor, and a third one is a felony. I had a client recently that he pled guilty to a DWI in '88, a second one in 1991. He was charged with one in 2019, and that's a felony. So, I mean, doesn't
matter how much time.
Technically speaking, no. I mean, that's up to the prosecutor, I would think, but I haven't seen a whole lot of leniency there from their end.
As part of the SIS or SES, do people have to go to rehab or get addiction counseling? For
a DWI?
Yep.
So a typical offer for first-time DWI would be SATOP, required substance abuse traffic offender program. SATOP's a two-part thing. The first part is an assessment. They're going to talk to you about, they're going to seem like your best friend. They're going to talk to you about when you start using drugs, when you start drinking, how much do you drink? And then they're going to go off that and maybe your blood alcohol content. After that, you do a class. It's going to be required usually for both your license and the courts to do the probation. Depending on how that goes, SATOP will compel you to enter a class, and there's levels to it. So if I got pulled over 0.2 and I'm falling all over the place and I'm vomiting in the cop car, they're not going to have me do the lowest level of SATOP where I come and go a couple of times. It's going to be way more intense than that, and that is required. So,
right. So I always think, and my gut, and I don't want to, I'm going to say it, and I could be wrong. I always think if someone gets pulled over for a DUI, they've done it 100 times before, and they're just getting caught that time.
Sometimes people say, I've heard statistics out there, like people do it a handful of times. I personally think that that's undercutting it.
Don't you think that I tend to think that this SATOP program is really good, because if someone is breaking the rules and drinking and driving, they have issues. They need to, I'm not judging. I'm not trying to I'm judging a little bit, I guess. I'm not trying to overly judge, but that's a way to target people who need help, who need intervention. And sometimes those SATOP courses can be successful and can divert people's drinking habits or drug habits and help them. Would you find that to be true?
I do. I think the biggest obstacle is it's very expensive. I mean, it's a two-part thing. It's $350 or so for the interview, the assessment, give or take, and then it's $150 for the class. And that's on top of hiring a lawyer and having all these court costs and fines. But I think it's helpful, and they do it right. I mean, they have different levels. I have a client, he blew .082. Okay, so does he deserve to be in the same class of third-time offenders or people who blew a .2 something? No, and they do a good job of, drawing that line and the different levels of treatment and who needs what. I do think it helps people, but ultimately those people leave SATOP, they're done, and it's going to be up to them whether or not next time they're out having fun, if they about their experience, and if it's going to be an ongoing deterrent for them. It's going to be up to the person.
Thank you, Eric. I got a question from Brennan. What is SR22? I don't get it.
Okay. Yeah, a lot of people don't get that one. SR22 is insurance, and it's reported to the Department of Revenue. So right now, if I got pulled over, I didn't have my insurance card, there'd be no proof I'm insured in any way. And SR22 is just like the insurance I have, but the company will send it into the DOR. So let's say you got suspended for a first-time DWI. If you blew in the breath test and you do get suspended, there's typically a 30-day suspension followed by a 60-day period where you can have a limited driving privilege, okay? You need the SR22 to get that 60-day driving privilege. So I tell people, just change your insurance over. Tell them you need, call Geico or whoever it is, tell them you need an SR22. Obviously, it's not good because they know something went wrong if you need it. It's required for people who get DWIs, people who have their license suspended in a number of ways. And it's just a way of the state knowing that you stop paying for that, it won't be on file and you will be suspended. It's just a way for Missouri to know you're insured. So it's a good thing.
Got it. Okay. Now, let me, I got another random one, which, you know what, sometimes these are fun too. Adam asked, yesterday on Jefferson, a reckless driver came within a foot of hitting my car while I was stopped at a light. If I swerved to avoid the car and I hit another vehicle, what happens? Am I classified as an at-fault driver? Is the initial reckless driver at fault for my collision?
Well, and Gary, I think you know that one better than anybody. I mean, in a perfect world where everyone stops, everyone's insured, and everyone's honest about their story, I would think that the driver that you had to avoid is at fault. That would be a disaster and a mess between every insurance company involved, pointing the finger at everybody else. But if they reasonably had to avoid that driver by pulling over to the side, it's not a great situation. But if it comes out fair, I would think that your insurance policy doesn't see an increase in your premiums. But
yeah, and I've had cases though too where, like a truck driver, someone else, they hit my client's car, but they say, oh, there was this phantom driver that came in and blah, 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 blah. And I'm like, those are interesting cases because, and I'm like, well, why don't you sue them? Make an uninsured claim against some phantom driver, number one. Number two is, what's fun in those is when they say it in a depot and you go, well, here's the police report. You didn't say anything to the cop in the police report. At the scene, you conveniently did that. I had a case where I did a deposition. I think this was right before Corona, where this guy had this truck driver who ran into my girl, had this whole story. And I was like, well, and this is like, you know how like you have 3 hours of deposition, but there's like one good part? Well, this was it. And I go, well, here's the police report. All right, exhibit 1. Here's your internal investigation, number 2. Here's your answer interrogatories, number 3. Now I'm going to show you these. Now this story you just told me, look in any of those documents. Is it anywhere in there?
Yeah, things change.
And then the next, no. And then the next question, did you make this up last night? So sometimes you follow the paper trail on that. So when you have, so I agree with you, Eric, when you have the legitimate third party pushing you into something, yeah, but can it be too easy an excuse that you're making up? Yeah, that can happen too. All right, let me move to another question. So I got a question for you. I'm going to show it here. So So I did this article. I've been talking about the McCloskeys a little bit because, Eric, you and I are both lawyers. I'm a plaintiff's lawyer. You're a plaintiff's lawyer, but more of a criminal defense lawyer. Bad lawyers in our business give lawyers a bad name, both as a personal injury lawyer or as a criminal defense lawyer. There's jokes made out of us as our profession because of bad lawyers. And one of the things we do is try to protect our profession. So anyway, from that point of view, I've been talking about the McCloskeys. I'm not trying to judge, any of this other stuff. I am a little bit, but anyway. But here's one question that I had for you. We can get into the McCloskeys and your views on it, but I wanted to know from the legal side what this castle doctrine that I hear about. The governor's talked about it in Missouri, et cetera, et cetera. From the legal side, let's move away from the politics side, but from the legal side, can you talk to us about the castle doctrine?
Sure.
What is it? What does it mean?
So and here's the, legal jargon, if you reasonably believe that using physical force is necessary to prevent destruction of your property or theft or a crime committed in your property against you or towards your property, you can use physical force. The question is, what's a reasonable belief? And, that's an interesting case. It's one that I can see from both sides, and it is unfortunately a little bit political, but the question is do you reasonably believe that the use of force or the threat of force is necessary to prevent a crime being committed against you, your property? And if that's the case, you can use the physical force. It's this case, there's a lot of gray area to it.
Is that in a statute? Is that a criminal statute?
Yeah, it's Section 563.041, the use of physical force in defense of your property.
So, but if like, for instance, if these, if the people you're afraid of aren't on your property, if they're on a street, you can't invoke it.
That's a tough one. I don't know exactly. Listen, I wasn't there. I don't know exactly what happened.
No, I know, but I use it. But it seems like from the way you said it, it's that if they're on your property, not like in the street. I can't pull out a gun because someone 3 blocks away is yelling at me. Right?
I think on that side, the argument's that they're not on your property. So why do you feel like force is necessary to defend your property if they're not on there? And I see that. All law aside, I just think the reason charges were filed, they're general conduct. It's just not a good look. It's not. And, a lot of times lawyers, their understanding of the law, they'll get a big head. They'll be very confident in what they're able to do, despite it seeming like conduct other people won't like. They'll want to act in a certain way because they know the situation and the law behind it. I see this thing kind of from both sides. I don't think it was appropriate the way that they handled themselves. However, that being said, they do believe that the way they were acting was appropriate in light of the circumstances under the law. There's a lot of aggressive lawyering going on both sides. It's just a very interesting case. Typically, these things are resolved when it's nonviolent through simple plea negotiations. However, the fact that we're talking about lawyers here, I don't think that there's any easy way out for either party. And they've hired excellent criminal defense attorneys to represent them. They're doing a great job. And we'll just have to. I'm interested to see how it shakes out. So.
Do you think that case is going to go to trial?
I don't think that I'll put it this way. I don't see them pleading guilty to UUW. unlawful use of a weapon.
Maybe on like the day after the election on November 4th, no one will care anymore, and it'll all go away. Either the prosecutor won't care or the McCloskeys won't care. I don't know.
I think the McCloskeys are, from what I understand, they're probably in it to win it. I think that I heard that they're being offered diversion, but diversion would require you more than likely to plead guilty to the charges. And I think it's a pride thing to an extent. And I don't see this getting resolved very easily or anytime soon.
Did you read that article about all the lawsuits they filed in the past and all that?
Yeah, and there's it's a mess. I mean,
did you know a friend of mine wrote that article? His kids and my kids. That is the most read and downloaded article in the history of STLtoday.com. Isn't that crazy?
A lot of people have taken a lot of interest in this. My thing is this: it's not that I'm not interested in it, but I mean, when did this incident happen? Was it like July or August?
Yeah. June, I think. June, and then it got rehashed, and then they've been riding this train for a long time.
Yeah, and I just think it's kind of like it's a distraction. I think how many homicides did we have in St. Louis City in July? I mean, just in the city, it was over 50 people. One of my clients, his first cousin happened to be one of the bodies out there, an 18-year-old kid, and another client's brother. And that's
how many
people are. What's that?
How many thousands of people have died from corona since then? My Lord,
80,000,
whatever.
We got a situation.
You're right, but that's why it's being used to be a distraction from what's really going on.
People are agitated, but they're all still here. They're all still alive. Everyone involved in that situation is doing just fine physically, but I think people are very entertained by it,
All right, let's move on. Good. Anything else on that, or can I move on? I got some other questions for you.
Go ahead.
All right, David. No, it's all good. I just, one of the things, on so many of these things, wherever you see these people talking all the time, and one of the things I try to do on this is I try to get to the questions and ask questions so that it's not just us talking, which is fine. But so let's move it and move on. Dude, I got a couple interesting questions from David. David asks, what difference does having an attorney make in a criminal defense case? Why should you get an attorney? Does that mean you pay less fines or potentially serve less time?
I mean, it can mean it's a world's difference. In the municipal courts here in St. Louis County and in St. Louis City, you're not going to get a public defender, to defend you in an ordinance violation or what's the equivalent of like a misdemeanor. It's a world difference. People who don't have a lawyer, they're typically going to go to court several times. It's going to take hours of their time. And if they do finally get to the point where they're sitting down with the prosecutor discussing the case, they're not going to know what to ask for. They're not going to know what to do. And they're going to leave there. If the case does get resolved, eventually they're going to leave there not having any idea if this was a fair deal or how it kind of worked out. When I have clients who have defended themselves in court before, they'll tell me that I didn't get convicted. And I'll look it up and I'll say, hey, sorry to tell you this, but you did. It's just important to have a voice. Not having a lawyer is dangerous, especially when it involves a criminal case. When you have a felony case, you're going to go to court several times without a lawyer, and the judge is just going to keep asking you. Most people who have public defenders, they're locked up in the jail. They're the people, it's proven that they need it. If they had a bunch of money, they would have posted bail. So generally speaking, it's a world's difference. Who knows what you could end up agreeing to? I have a client who has a felony stalking in St. Charles County involving an ex-girlfriend. He doesn't have any priors, okay? The offer, he did not have a public defender. He was going to court on his own. The prosecutor offered him an SES for a first-time felony, so he would be a convicted felon with 5 years, full 5 years probation. The SES with a backup. I don't remember how many years it was, but I think it was the maximum they could sentence him to in the backup. and anger management classes, domestic violence classes, even though it wasn't a violent case. And he could have accepted that. They were putting pressure on him to accept it. If they did that, he would have a conviction of a felony on his record. He would have miserable probation terms to get through. And when you get a lawyer involved,
people need to remember that and I don't want to cut you off, but listening to you say that, it's kind of like me in the civil, like in the PI case, because I say, this ain't my first rodeo. I know how to do this, and because the criminal law and criminal charges, as well as on the civil side, it's an adversarial system. That prosecutor is not looking out for the person charged. They're there to get as much of to do as well as they can against them. So people who go into court, people do that in housing court and others, but if you go into court by yourself thinking that the attorney on the other side is going to do you a favor, going to be straight as shooter with you or act in good faith with you, it's just not going to happen. Because there's nothing wrong with them. They're doing their job. They are sworn to get the best deal that they can. Just like Eric, you're sworn to do the best by your client. It's just the way it works.
Well, it's like that in personal injury, Gary. Like you get in a big car accident, you go to the hospital once. You haven't hired a lawyer yet. What's that adjuster going to do? They're going to get to you early on before you get any additional treatment that you may need. And they're going to say, hey, you don't have to split this money with an attorney. Take this $1,500. You don't have to share it with a lawyer. We'll pay the hospital bill. It's tempting for people who don't know better. And the thing is I guess my thing is the difference between a prosecuting attorney and an adjuster in that situation. They just resolved a claim that could have been worth several thousand more than what they sell it for. I don't know if there's actually like financial compensation for that, but they're certainly it's awful what they do to people, but they're doing a good job at what they're doing. I don't know. I think the prosecutor, they need to use a little more discretion.
Can a person? I am following up with another. I hear you. I following up with another question from David. Hmm. Can the person go up and negotiate with the judge on their own without a lawyer?
So yes and no. I mean, the judge cannot amend a charge. So let's say you get charged with possession of marijuana, and the reputation around St. Louis County is you might be able to get it bumped down to littering. A judge can't do that. The only person who can amend a charge is a prosecutor. So the only thing there is to negotiate with a judge is after you plead guilty and what the result is. A judge can give you an SIS, but a judge cannot take a charge and make it something else. So the negotiation, sure, you can negotiate some probation, maybe you get a great deal, but most of the negotiating, like a misdemeanor happens with a prosecuting attorney. They have the authority to do a lot more for you if they're so inclined. So.
Great point. Great points on that. So that answers the question. No, get a lawyer. Call Eric. I'm going to put up your stuff again, Eric. All right. Are you like me, Eric, that you answer people's questions at least from the get-go for free? Let them know the deal?
They do free consultations. Sometimes people, take all they can get, and usually I'm always happy to help. I don't charge for phone calls or questions, though.
Good. What's worse if you're on probation? Another conviction or jumping bail?
Those are both terrible things. I always tell my clients, there's two awful things you can do on probation. You can catch a new case, meaning you're completely disregarding the fact that you're on probation. You not only committed more criminal acts, but you've been caught and charged. But those go hand in hand. Typically, someone will jump bail in that situation. So that's called absconding. That's kind of running from your probation office, not responding. So you're making it look like you can't go a significant period of time, even with all this on the line, without catching a new criminal case. You're also looking like you can't do the probation. You take off and run on them. Either way, doing either of those things, you're more than likely to get locked up on the new case, and then you're going to have to bail yourself out on the new case in addition to the case you're on probation. You'll have to have a bond on that. So you'll have two cases, the probation violation, the new offense. If you have an SIS on the case you're on probation, you're more than likely looking at a conviction or jail time by getting an additional case. And you running, it only makes it worse. Your bond's only going to be set higher because you'll be seen as a flight risk.
Right. Hey, so let me ask you this. Who's Scott Thaler?
I see that he's asking some strange questions. It's my mother. I believe he's my mother's first cousin. He's a family and a friend.
He asks a lot of funny ones, but he asks a couple good ones. Not that they're not all good, but he's funny. I'm sure there are stories behind these, inside jokes. But here's one. Can you get a DUI for prescription drugs you've been taking?
Yeah, I see that all the time. So I defended this young man that was on prescription medication, basically like Xanax. He had terrible anxiety. And, there's that catch-all on the pill bottle. Don't operate heavy machinery if you're not able to do it in a hand. Basically, if you get caught driving and you don't seem to have it together and you don't have possession of your full faculties, you can't blame the prescription medication on it. So I've seen that a lot. Usually, people have a hard time correcting their behavior after getting one. And a lot of it's because you're prescribed this medication and it's medically necessary. But yeah, it's just like a DUI test where a breath test is refused. They're going to go in large based on the officer's observations. If they go on these hints that you're driving under the influence of these drugs, it's all about whether you were in full possession of your faculties or not. And a lot of it turns into their word against yours and their observations. And a lot of the times those cases do end up going to trial based on the lacking evidence. But it's not an easy slam dunk on either side, typically. Those are very difficult.
All right. I'm going to take a question. Usually, Eric, when I do these, like I'll answer a question, the other guest will answer a question. This, you're getting them all. But that's because I'm revealing my lack of knowledge about criminal law. So I'm so glad to have you on here. Scott asked another. I'm only going to give two questions for Scott. This is the second one. Would having a Trump 2020 or Biden 2020 make any difference in a court of law? The answer is yes. Look at who subscribes or obeys the law versus who flaunts it. I think the distinction's clear, and I know that's a little one-sided. But if you look at the courts and who judges appointed to courts, federal courts are appointed by the president with advising consent to the Senate. Trump has appointed a ton of judges. We have serious, all these criminal issues go up to ultimately U.S. Supreme Court. We've all a lot of us have followed the politics on that recently. So it does make a difference in that way. Now, on the day-to-day stuff that when I'm on my deposition tomorrow or Eric's court appearance tomorrow, it's not going to make that much of a difference. But ultimately, when these things are decided, and then that message gets handed down to the trial courts, it does make a difference, and it affects people's rights. So there you go. I answered that one. But anything on that, Eric, or can I move to the next?
I think you're right in the aggregate, and it kind of trickles down. However, in this little world that I live in, and I'm defending ordinance violations and local laws. I don't think whoever's elected. I'm not going to call one of my clients with a pending case and say, oh, we're in real big trouble now based on this election. I thought the case was going well. It's not like so concrete to my clients at the state level or the municipal level, but I do, everything has consequences and it trickles down. So.
But it does affect too on enforcing of tort reform, enforcement of criminal laws, double jeopardy issues, Miranda issues, all those issues, whether it's a criminal or the civil case, having higher courts weigh in on this stuff. It's not as much of a direct day-to-day cause and effect, but bigger. It does affect us, I think.
Bigger.
Yeah, I think we agree. All right, so here's one. I haven't seen these in a long time. Sobriety checkpoints. Do they still do them? Are they constitutional in Missouri or Illinois?
No, I haven't seen them in a very, very long time. But what I do see is, have you heard of the term saturation Saturdays? Certain weekends where it's anticipated there's going to be more drinking, more partying, more drunk driving, like a 3-day holiday weekend. I think last I heard from a public defender, I think it was 2 weeks ago, And it's not like a checkpoint kind of thing, but police are out there looking. It's one thing to kind of come across a guy swerving and looking intoxicated. They're trained to kind of look for it, expect it to happen on these days. And I think that that's a much better solution to the issues with someone with safety out there and drunk driving. I think if you understand it's happening on a certain day and more likely and you're looking for it, you're going to keep a lot more drivers out on the road a lot safer than stopping traffic and just checking everybody. And I haven't seen a DUI checkpoint in a long time. They are unconstitutional. And, I think what was funny is some of the local lawyers and some of the national lawyers, they recommended you putting a little plastic baggie outside of your window and roll up your window, and it would say, it was like a DWI baggie, I think they call their package. And it would say like, sir, I'm not rolling down my window so you can lie and say I smell like alcohol. I am exercising my right to an attorney if I need to any further. And it basically just says, I'm not talking to you. I'm not dealing with this, And, I think I haven't seen a sobriety checkpoint in some time now. And I think it's better the way they're handling it now.
Let me ask, I got more questions here. We're getting close to the end here, but what about prior criminal history? Does that affect how a new case will be handled? Same for injury cases. If you file injury claims all the time, does it change the outlook for results? So I think you talked a little bit about prior criminal history already, Eric, on at least the DUI front. Any other way that I'll talk a little bit about on the civil side, but any other way that criminal history or prior criminal convictions or history affects a subsequent case?
It's a world's difference. I would say, they can enhance the charges by charging you as someone who's prior and persistent or an aggravated offender. Let's say I got a couple drug cases, that were 10 years apart, possession, not harming anybody, not harmful to any individuals physically. But if I keep showing a pattern of that, if I get a third case, I can't expect to plead guilty and have the judge give me an SIS and allow me to remain non-convicted. I mean, criminal history is everything. It shows the likelihood of you repeating that behavior. I'm always very happy when my client's in this jam and it sounds tough, and then they manage to tell me, I don't have any criminal history. It makes me feel a lot better about the situation. It makes me feel it's negotiable. I have had clients who are like, I guess, kind of career criminals, and they get out of prison, they do what they do, and they go back, and their frequent flyer miles are off the charts. And we're not ever talking about probation when we're trying to negotiate it, and it can make a world's difference. And, if you're 18 and don't have a criminal history and you're shooting at somebody, we're probably not talking about an SIS just because you don't have a history. So there are exceptions. But for someone who's nonviolent, I would say criminal history shows a likelihood you can learn from this or you can't. And on the civil side, it really affects it too. But the first thing you wonder is it's going to come in evidence, because it's not as relevant at a trial unless it's a lot of judges will keep it out. Now there's but if you have a felony or a crime of moral turpitude, then sometimes that'll come in. It's not going to really matter what relevancy is a felony conviction 10 years ago if you're sitting at a stoplight and get rear-ended? You didn't do anything. Right.
What's the relevancy? But if it's a he said, she said, or if there's some challenges to the veracity of your medical history or that kind of stuff, it can come into play. Drinking, I had a case where I got rid of the case because we were going through about 800 pages of medical bills, and we found a bunch of alcohol at the scene of our plaintiff, which he did not tell us about, so we got rid of that one. I had a case one time, we were in a deposition. A friend of mine was deposing the client, and he's saying to her in the beginning of the depo, he's like, now, did you serve federal time? Nope, did not serve federal time. And he went through all these criminal convictions. She denied everything. And then about an hour later, he's saying, now I have here a record of you getting neck treatment in Leavenworth, Kansas, in blah, blah, years. He's like, oh, yeah, that's when I was serving time. And so you served federal time. It's something you didn't remember, and you got medical care there, and here's the medical record. And so my advice to people, but at the same time, just because you have and I don't know the parlance, but you draw a charge or whatever, you get convicted, that doesn't mean people can hurt you or run into you or sell you a brag product or have an icy sidewalk or a truck driver can't go smash or any of that stuff. I mean, you still have rights. You don't give up your rights to get compensation for that. So if you come, the one thing I don't like is not to know it right away. So I like when I ask someone, they come and say, yeah, here's the deal. I got blah, 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 or I have this, that, or the other thing. That way we know how to handle it going forward rather than it being a surprise. The surprise is what kills you because most good defense lawyers hide it until the depot, and then they're deposing your client and they're going wham, 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 and you're going, oh man, it's going to kill your credibility. So it is what it is. You know what I mean?
Let me ask you a question, Gary. Is that okay?
Yep.
So let's say you have a client, and let's all, pre-existing conditions aside. Let's just say this person's very litigious. They've had 9 claims in the past 4 years for soft tissue injuries. They're quick to file. They're quick to sue. They're quick to open up a claim. You get them for number 10. It's another soft tissue case. Does that change anything in the way you handle the case or your outlook on the case?
Absolutely. Frequent fly. It shows that there is a more of, I don't want to overstate it, but it shows that maybe they run to that stuff. Maybe they're over treating. It tells you they're going to have a lot of prior treatment. So you'll go those 5 cases or whatever your hypothetical was. The defendant will go get all that medical and be able to show the jury this is the exact same neck complaints they've had in 4 other cases. So do you think it really happened here, or what is the permanency of these other cases of the medical from this case? How much did this neck damage really add to it? So don't give them any money. There are frequent flyers, and I wouldn't take that unless there's a real reason. And you know what I do is I have a real conversation with the client. When I try to teach other lawyers, I say, you sit down, you look at the client, like you and I are looking each other in the eye. What's the deal? Why'd you tell me about these cases? Why are you doing this? Is this a way for you to make money, or are you legitimately hurt? Are you with the wrong person in the wrong place? I have a number of cases, literally in litigation now, where I have multiple accidents, where I'll have someone who gets in a wreck, treats, blah, 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 and then gets in another wreck. And you know what I do with those cases, Eric, is I double down on them and I embrace them and I file suit in both cases at the same time, because the defense will try to point to each other. And I'll have cases like someone rear-ended twice or someone no fault of their own. And you sit there and look at the jury and you say, hey, they didn't ask to be this. The last time they wanted to have one and have a lawyer and do this, but now they have 2. But we got to sort it out, and here's the deal. So, but like that many claims over that history, that's something that would scare me away from a case without knowing.
You think your outlook on what you're able to do with it is significant. If they're clearly not at fault, they're rear-ended, but they've got a huge history. That's a case you typically will try and stay away from.
Right, because what they'll do is the defense lawyer will pick up the medical from 3 years ago and said, you had all these problems before. So, it's like the boy who cried wolf, right? It's not that complicated. All right, I want to shut this thing down, Eric. I try to make them an hour. Do you want to talk about protesters being prosecuted based on photos found on social media? Is that true? If you've ever seen that?
I mean, I've seen, maybe not with protesters, but I've seen a number of young clients put up things on social media that is so far against their interest. It's painful to see. But yeah, I mean, that stuff, typically a prosecutor will already have proof of something, but then you're just giving it an open and shut case by putting up, if you have a bunch of photos with guns, it doesn't mean that they're loaded. It doesn't mean that they're stolen. but it kind of says something about your character. And oftentimes, a client of mine, before they're a client, they'll have photos of things that they've stolen from people or been accused of, weapon they've been accused of hurting someone with. And it's upsetting. I don't even know what to say about it, but it's very painful. And as a defense lawyer, I look at that and I just do what you can. But yeah, social media has definitely helped prosecute countless crimes. And it's amazing that people don't understand that. Now, anything you're being accused of, if there's anything on social media to back up, any of their accusations, it will be used against you. And I can't argue with that.
No, a picture is worth 1,000 words.
Yeah.
All right, Eric, I can't think of any other good questions. Your cousin Scott, I posted his thing up on the thing. He's got your back, though. Your family's got your back, as they always should. So
he's a character.
He is a character. Eric, as I said before, here's Eric's website. Call Eric with criminal questions. Call me with PI questions. It's always a pleasure to talk to you, Eric. I haven't seen you in a while, so it's great to see you.
All right. Thanks a lot, Gary. I appreciate it.
All right, keep on fighting the good fight, Eric. Thanks, man. I'll see everybody next week.